So you're being charged with a crime. You've never gone through this process before, and it's intimidating. This whole video is about how the criminal case process works. The first thing that has to happen is to be able to discern whether or not it's being charged as a felony or a misdemeanor, because it does make a difference. Felonies and misdemeanors are similar in some ways in that the first court hearing that you go to is called the arraignment. This is your first opportunity to plead guilty or not guilty. The second process is called a readiness conference. This is the first opportunity after you've reviewed the police reports to be able to figure out what they're accusing you of, what evidence they say that they have, at least at the beginning. And the readiness conference is your first opportunity to talk with the district attorney and see if the case can be negotiated, or if you can present some sort of affirmative evidence that conclusively proves that you're not the person who did it, that you weren't around, any number of different things. But that's your first opportunity. And this is where the difference between a felony and a misdemeanor diverge. If it is a misdemeanor, you continue on with readiness conferences until such time that you either say, I'm not going to resolve the case and I'm going to take it to a trial, or you resolve the matter. But in a felony, the next process is called the preliminary hearing. The preliminary hearing is the process where the district attorney has to put on what they call a prima facie case, meaning they have to put on just enough evidence in front of a judge with live witnesses to be able to convince the judge that there is probable cause that a crime has been committed and you are the person who has committed that crime. Once that occurs, the judge will do something called a bind over, which means they're not going to change the complaint into an information, which is a more serious charging document, and saying that you're bound over, that you're being held to answer on those felony charges. Now, at this point in time, it kind of like the process starts all over again, because you're going to be arraigned on the information, plead guilty or not guilty. Then we start off again with readiness conferences, and we try to negotiate it out to find out what evidence was presented. Now, at the preliminary hearing, there might have been evidence that was in your favor, that is going to increase your bargaining power with the district attorney, or it could be more damaging, and it's going to decrease your bargaining power with the district attorney. Whichever way it happens, the readiness conferences occur. At some point in time, the district attorney is going to say, this is our offer, take it or leave it. And at that point in time, as the client, you decide whether or not you want to take their offer or whether or not you want to take it to trial. At all aspects, if no negotiation is successful and no plea agreement can be reached, the end process of every criminal case is a trial. And we'll be discussing each phase of the criminal trial, both on the misdemeanor and the felony side, later on in this video series. Please check out our other videos, and you'll be able to see all the different parts of the process and how they work. Thank you.